Hello, everybody. I can't thank you enough for taking time out of your day for this month's webinar, and what a webinar we have planned for you. I think you're really going to get a lot out of it. Before we get to it, I hope everybody's staying healthy and well, and we're thinking of you all the time, and I can't thank you enough, as I said, for all the trust you put in us and for taking time out to try to kind of maybe learn a little bit more. So with that being said, let's get started. Today, I have great presenters. We have Harmony Wagner, certified financial planner and one of our senior wealth advisors, and Harmony and Scott, who is also one of our newer wealth advisors, one of our associate wealth advisors. Some of you may not have met Scott yet, but he's really an amazing asset to our firm, an enrolled IRS tax agent. And between Harmony and Scott, I think you're going to get a lot out of today's seminar. What we're going to discuss is what is estate planning, what estate planning documents everyone should have, when to consider more complex planning, and lifetime strategies for leaving a legacy. So with that being said, I'd like to hand off the presentation to Scott, who will get started.
Thanks, Steve. So what exactly is estate planning? Many of you may be thinking of the basics like a last will and testament, power of attorney, and some sort of trust document or trust agreement. Well, whatever comes to your mind, only about a third or 33% of Americans have an estate plan in place. Two of the top reasons that people typically do not have a plan already in place is one, they just simply have not gotten around to it. And then two, they believe that they don't have enough assets to leave to any of their beneficiaries. Estate planning, though, is not just for the ultra wealthy and celebrities. It involves a lot more aspects of your life than just what happens with your affairs upon passing. Over the course of this webinar, Harmony and I will show you what it takes to make up an estate plan and why now is the time to act upon your estate plan.
Thank you, Scott. So let's first think about why estate planning is so important. And to answer that question, let's think about what happens if someone dies without any estate planning in place. As Scott shared, there is an overwhelming number of American adults who do not have this in place at any given point. So this happens more often than you might think, that someone passes away and they have not done the proper estate planning. Either they don't have documents in place or they're not up to date. We can think about an example that many people probably remember when the celebrity Prince passed away in 2016. He did not have anything in place. He had, of course, substantial net worth. And, what happened to his estate? Someone with, a lot of assets that didn't have any planning done. What happened? We can look at that as an example. Now, because he didn't have anything that expressed his wishes, it went to the laws of Minnesota, and the state decided, and that is what would happen to anyone who passed away, what's called intestate, meaning that you did not have a will or other documents that would define the flow of your assets. So, Prince had, a lot of assets. He did not have a spouse at the time. He had been divorced. He did not have any living children at the time, and his parents had also predeceased him. So his assets went to his 6 half siblings who were living at that time. He paid tens of millions in estate taxes to the IRS because he had not proactively planned to avoid those. And the estate took 6 years to settle. He passed in 2016. It was not completed until 2022, just last year. So we think about that, and of course that's an extreme example. But we think about, and you can argue that in a number of different facets, that probably is not what he would have desired for his wealth over time to be given to those particular individuals, perhaps. Certainly not for so much to go to the government and taxes, and to take such a long process. The answer is similar of what would happen to anyone who passed away without an estate plan in place. It would depend primarily on your state, but also on your family dynamics. Let's look at New York State as an example, since many of our clients are New York residents, and it's a good example of how the state's defined flow of assets may or may not be what you would want if you were choosing it yourself. In New York State, if you die intestate, the first $50,000 of your wealth goes to your current spouse if you have one. After that, any remaining assets beyond that 50,000 get divided evenly between your spouse, who receives 50%, and any living biological or adopted children that you have at that time. Stepchildren and foster children would not be included unless they were legally adopted at the time of your passing. Now, you can think about this and realize that that does not align with what most people would want. For many folks, they feel that, if they have a spouse at the time of their passing, they would like all their assets to go to that person first. And when that person later passes away, then it can go to children and grandchildren, nieces, nephews, subsequent generations. But that's not what would happen under New York State if you didn't have something else outlined. If you had no spouse living and no living children, your estate would go to your parents. If they predeceased you, then it would go to your siblings. If you didn't have siblings who were going to inherit it, then it would continue on. And New York has a predefined family tree, so to speak, of how the assets would flow. In addition to having the state decide what happens to your wealth, they would also have to go through probate, which is the legal process of determining what you owned and who it was going to and who might have some claims to it. That could be a really long and difficult process, and it is a public process. It is not private. So your wealth is on public record for anyone to see what you had at the time of your passing and what your heirs are inheriting. So for many reasons, it makes a lot of sense to have estate planning. If you want something done that's different than what the state would say, then you certainly want to put estate documents in place. If you want to avoid probate, which is a reason in and of itself to do this planning. And there are also parts of an estate plan that affect you during your lifetime as well, as Scott alluded to. So let's talk about some of those documents that really pretty much everyone should have as part of their estate plan. The first is beneficiary designations. You should have these on any account that allows it. So investment accounts, retirement accounts, that includes your employer plan, like your 401k or 403b. Bank accounts actually allow you to have a transfer on death person or person's name, which some people aren't aware that on a bank account, you could actually have a beneficiary as well. Those things make for the smoothest transfer of assets and the fastest after your passing. The institutions can receive a copy of your death certificate from the beneficiaries, and the assets will automatically and typically very quickly flow to those people that you had already designated. It's important to keep these up to date, of course. Maybe you had a spouse named as your beneficiary and then you were divorced from that person. You want to make sure you're updating your beneficiaries. Or if you have your wealth going to your children and you have another child that is born later or children born later, you want to make sure you're including them to make sure that they receive the share that you'd like them to have. So it's important to keep these up to date, but they are an easy and an important way to structure the flow of assets. Next is a will. And that's probably what most people thought of first when we talked about estate planning. That is a document that can express a lot of important things. You can define who you want to be the executor of your estate, who's handling this after you're no longer here. What about assets that can't have a beneficiary named, like your home, other property, maybe jewelry or artwork or other collectibles, things that are important to you that you want going to a certain person that you can't have a beneficiary on. You can also have guardianship designations if you have minor dependents. That's really important as well. So a will can outline so many of those really, really key estate planning information. Next are some things that could potentially affect you during your lifetime. An advance directive or a living will. These are similar. A living will is a little bit more broad in scope, but these are both documents that define if something were to happen to you and you were in a medical crisis where a decision had to be made about what kind of measures or care you'd like taken, you can define that with a document like this. A living will is a little more expansive, as I mentioned. It includes if that situation were to arise out of a terminal illness. So having a document like this really takes this decision off the weight of your loved ones, off their shoulders. They don't have to be the one thinking, oh, what would that person want or not want in this situation? You can lay it all out in a legal document so that you're ensuring that the right type of care is provided that you would choose for yourself if you were able to in that moment. And lastly, here we have medical and financial powers of attorney. So making sure that the people who or person who you'd like to make your medical or financial decisions for you, if you were not able to, that you have those people legally named legally empowered, and you'd also want to make sure those people are aware of the responsibility that you'd like them to have if that situation arises, especially as folks advance in age. This is a great thing to have because it can happen over time, but there may be a day where you're not able to make the same kind of decisions with the same kind of prudency that you would have earlier in your life. So it's important to have these in place before the need arises. So these documents are ones that pretty much everyone should have in place and up to date. These are going to help you avoid probate and make sure that all your wishes for your lifetime and afterwards are carried out. Now, often when clients come to us and either they're starting from zero with an estate plan, or they're just having these questions of, is something missing from my plan? A question we often get is, do I need to think about something more complex? Do I need to be worried about having a trust in place, or some other strategies that I need to take action on? Maybe you've heard your neighbor or your sister saying, "Oh, I have this trust. You need one too." Well, without knowing that person's total situation, it's hard to say whether you need the exact same kind of estate planning instrument that they have. So here's a list. It's not all inclusive by any means, but it includes some of the most common reasons why an individual or a couple might want to consider some more complex estate planning beyond the documents I mentioned on the last slide. If you have assets that are above, or I could argue if they're near, the federal and or state estate tax exemptions. So for both federal and state, there is a level for individuals that if your estate is above that threshold, you will pay estate tax to the tune of 40% of the amount above. So it is, highly motivating to take action if you feel that you may be at risk of owing estate tax. For federal purposes right now, the threshold is 12.92 million per person. So for a married couple, you have almost 26 million between the two of you. That's a high threshold. It is one of, if not the most generous estate planning thresholds or exemptions that has historically been in place. There is certainly a possibility that it could get rolled back in the future. Something changes politically, legislatively, that number could absolutely come down. So keeping an eye on that is important. For most folks, you're not likely to be near that, 13 million per person. So it may not be as much of a worry. Depending on your state, you may need to do some planning there, however. Some states choose to adopt the federal threshold, others don't. New York State is one of the ones that does not. It has a lower estate tax exemption of 6.11 million per person. The other main difference with New York State is that unlike at the federal level, a married couple has what is called portability for federal. So you really share about 26 million of exemption. If one spouse passes away and they've only used 3 million of their 13, that 10 million left over can transfer to the spouse. So you're really sharing 26 million between two people if you're married. New York State does not have that. You cannot share exemptions for state purposes. So let's say you and your spouse have an estate of, about 8 million or 10 million, we'll say. And you think, okay, we're under the 12 million, we should be all right. Well, if one of you owns 8 million and the other owns 2, if that spouse owning 8 million passes away first, they're actually going to be subject to estate tax on that 2 million above the exemption, because you can't be sharing it with your other spouse. So there is certainly some reasons, especially for New York State residents, and some other states have different rules. So it's worth looking into if you're not in New York State. There are some more compelling reasons to potentially plan for the New York State estate tax exemption and avoiding paying estate tax there, which can be punitive. Another reason you might consider more complex estate planning: do you have a loved one with special needs who's going to be inheriting some or all of your wealth? You can set up a trust for that person so that an outside trustee, whether someone you know personally or a corporate entity, is handling and overseeing both the management and the distribution of those funds, making sure that it's managed in a prudent manner, that beneficiary has everything they need, but that it's not being, squandered or, going to anything that's inappropriate for that person. But in a similar note, if someone that is inheriting some of your wealth may have poor money management habits, maybe they're a young person, maybe they're 16, 17, 18 right now, you feel that they're not responsible enough to handle a large sum of money, or they could be older and you just say, this person hasn't shown that they have the capacity to handle this prudently. You can set up a trust for that person as well, and saying, I want someone else looking over it and making sure that these funds are used for the right purposes. If you have a desire for Medicaid planning, so a concern that many people have is how expensive long-term care costs can be. If you've helped a parent or another loved one go through that process, you may feel that more acutely for yourself, that it is really expensive, and it's a worry of a lot of people is if I need long-term care, is that going to deplete my wealth? So one way to approach that is through Medicaid planning, and you can use asset protection trusts to remove assets from your estate and allow yourself to qualify for Medicaid to cover long-term care expenses. There are some pros and cons to it, and there also are other ways to approach the long-term care decision, but this is one way, and if you have a desire for that and it's a big concern of yours, it may be worth a discussion with an estate planning attorney and or your financial advisor about what that would mean for you. Another reason could be if you have a complex family structure. Maybe if you are married to someone, but you and or your spouse have children from previous marriages. If you die, you want all your money going to your spouse, but after they pass away, maybe you want it going to your children, or you want it going in a different manner. That could be one reason to look into some trusts. If you have a family business that may have some complexity around, what happens if you're no longer in the picture, you could do some more planning around that. So anything that adds an extra layer of complexity to your family situation could be a reason to talk to an attorney and say, hey, do I have the right documents in place? Do I need anything more fancy to cover these concerns that I have based on my particular situation? Like I said, this is not an all-inclusive list, but these are some common reasons that someone may need to pursue some more complex estate planning maneuvers. So if you have any questions about this or about your situation, please give us a call. We can help start that discussion with you, help you determine what, if anything, you might need beyond the basics. With that, I'm going to turn it back over to Scott, who's going to talk about some common pitfalls.
Thanks, Harmony. With like any plan, the best plan can be drawn up, but you always turn up running into some shortcomings. Many of these shortcomings can be avoided by simply thinking about them ahead of time and addressing them. So some of the common pitfalls we'll see is 1, failure to act. As stated earlier, a lot of people simply do not have an estate plan in place because they just didn't get around to it. And hopefully by the end of this webinar, you feel as if you're ready to act upon creating your estate plan. Next, we'll see failure to execute. One possible example is having all the trust documents drawn up, but never funding the trust or ever changing the title on a deed. Next, we'll often see failure to update. It's important that your plan evolves as your life and your particular situation at the time does. Your plan needs to be reviewed and updated to reflect major life changes. Next is too narrow of a scope. As Harmony had mentioned earlier, we often can try to avoid the long process of probate. So your plan may be set up to avoid probate, but you may not consider a complex issue like estate taxes because it was something that you hadn't thought about given the high exemption thresholds. Next, we often see people doing it all on their own. People are often trying to do it all too much, which can lead to nothing being done or even costly errors that can cost them thousands or hundreds of dollars. It's important that you seek the right professional help like an attorney or a financial advisor. Both of them will help ensure that your plan addresses any of these shortcomings while also abiding by your wishes and intent.
As we kind of come to the end of the estate planning discussion, I'd like to talk for just a moment about legacy planning. And, I find for many of our clients, this can be a more meaningful part of this whole estate planning process. Estate planning describes what happens to your tangible assets, your money, your home, valuables after you die. Legacy planning is really, a more broad term that talks about what the intangibles are, who are the important people in your life, what causes are close to your heart, what meaningful legacy do you want to leave behind and do you want to begin creating during your lifetime? And that's what a lot of these kind of strategies do focus on is, you want to have everything squared away so that when you pass away, you know where everything's going and you feel comfortable about that. That's super important. However, there are things you can do during your lifetime that really help accomplish you in building that legacy that you want to build. One of those things is charitable giving. So many of our clients and many people have charitable interests, whether small or large. And it's so important to, as part of a meaningful and fulfilling way to use your wealth, that you accomplish those goals, that you see through the things that you want to see accomplished for certain causes or certain organizations that you care about. So, doing things like, giving money to charity during your lifetime, doing so in a way that is tax optimal for you and the organization that's receiving it. So one example might be if you have some highly appreciated stock or property, giving that to a charity instead of cash, you're avoiding some income tax that you'd have to pay. The charity can do what they need to do with it without paying taxes on it. And you also get to, appreciate the benefit that you're giving during your lifetime. On a similar note, giving to your loved ones during your lifetime can be great as well. Instead of waiting until you pass away and, having your family members inherit a large sum at your death, you can be giving money to them during your lifetime. You get to see them enjoy it. You get to enjoy the benefits of it as well. And oftentimes you find that the timing really lines up better when you do it this way. If you pass away in your mid-90s, which we plan for all of our clients, we run our plans out to age 95. Well, by that time, your children are probably in their 60s or 70s, and they may not need the money from you as much as when they're buying their first home or sending their kids to college. So when you take more of a lifetime approach to, how can I maximize the impact of my wealth? That's a great way to do it, is giving to loved ones during your lifetime. In a similar vein, investing in experiences, building those memories with family, going on a family trip, and maybe, you front the money for it, you foot the bill, so that your family can experience a memory with you that you will all have for many years to come. You can invest in things that are of high priority to you personally, like education for children or grandchildren. You could open and fund a Roth IRA for kids or grandkids or nieces or nephews who are working and have earned income. They may not understand the benefit of that tax-free growth at first, but you do, and you understand the benefit of saving for retirement, and you can contribute to them in a really meaningful way by doing that. It's important to note that for any of these items, you should be working with a financial planner, right? Because you don't want to be giving away during your lifetime to your own detriment. You don't want to give away a large gift at 50 years old and realize later that you're going to run out of money at 75 because you were a little bit overzealous in your gifting earlier on. You really want to work with a planner who is looking at this holistically and helping you do it in a prudent way so that you're protecting yourself, but you're also, not dying with millions that you never got to enjoy, that you're really accomplishing the things that are important to you from a value perspective during your lifetime and when you're no longer here. One other item on this note that I want to mention, it's so important to us here at Boucher, is setting up the future generations for success. And I have a statistic that may shock you, which is that 90% of the time, wealth will not continue through a third generation. So that means that if you are a first generation person of wealth, and maybe your parents struggled, but you did things differently, and now you're in a spot where you're the first person in your family to have any wealth to speak of. If you do not take intentional action now, there's a 90% chance that your grandchildren will not sustain the wealth through their own lifetime. The primary reason for this, 65% of the time, it's because the heirs are not prepared and equipped to handle money. So starting this conversation early during your lifetime, making sure that your children, grandchildren, nieces, nephews, whoever those next generations are, that they're connected to the right people. That's where we often come in, is talking with our clients, children and grandchildren, to make that connection, to make sure they're doing the right things, that they know who to go to, that they are working with a fiduciary early on in their lives, so that by the time the wealth gets to them, they know how to handle it and can sustain it to the next generation. This is really so important, and it's an important part of legacy planning, because otherwise the wealth that you've worked so hard to build, and you may think, my estate plan is locked in. I know that there's a lot of money going to people I care about after I'm no longer here. Well, if you don't take action to make sure they can handle it, it may not last the way you envision it. So it's such an important part of legacy planning. Scott's also going to talk here for just a moment about how different assets are treated for heirs, and the way that you can kind of think about that holistically when you're thinking about, how is this going to affect the people that I'm leaving money to?
As Harmony was saying, setting up the future generations for success is very important. You really need to think about how each one of your assets is going to affect your family members. Each asset, depending on your goals, could be constructed in a particular distribution strategy to help minimize not only your taxes, but also your beneficiaries' taxes upon passing. Here are some things to consider about your major asset types from the point of view of your beneficiary. Just note that all of these treatments are the most common scenario and may not be applicable to your particular tax situation. So be sure to consult your tax advisor. So for IRAs and 401ks, they must be distributed within 10 years of the decedent's passing. All of the distributions that are taken from these accounts are taxed as ordinary income. Roth IRAs and Roth 401ks also must be distributed within 10 years of the decedent's passing, though these distributions are tax-free. Taxable accounts and real estate, they all receive a step up in cost basis to the fair market value on the date of the decedent's death. Any further appreciation from that fair market value would then, if it was to be sold, would then be taxed as capital gains. Then non-qualified annuities do not receive any step up in cost basis for your heirs upon your passing. All of the gains in these accounts are taxed as ordinary income. In addition to making today's webinar available for everybody, we have also put together these two checklists, which will be available for download. The first one is an estate planning checklist, which will give you 6 action items to consider while developing your estate plan. The other is a checklist of documents you should gather and store securely. It includes documents like birth certificates, insurance policies, power of attorney, trust agreements, and wills. You may even want to consider putting all of these documents in one location, possibly a safety deposit box, and then even sharing it with other people, including your attorney, your financial advisor, executor, or trustee. And I'll turn it back to Harmony for some closing remarks.
Thank you, Scott, and thank you to all of our attendees. I hope you gathered something valuable. The one thing I would urge you is that a successful estate and legacy plan involves partnering with the right people. So wherever you find yourself after today's discussion, if you feel you're starting from nothing, reach out to us. We can help you determine what you may need, what kind of questions to ask, and connect you with a trusted estate attorney in the area that will, do right by you. If you have estate plan documents, but you feel you need to update them, we can be involved in that process as well. And we'd love to help and make sure that nothing else is missing, that there's nothing that you should have considered that maybe you didn't. Or maybe it was the legacy planning piece of the conversation today that resonated with you the most, and maybe has your mind turning of, what should I be doing in my lifetime? Are there ways that I can, maximize the impact of my wealth for not just myself, but the loved ones that I'm going to be leaving it behind to one day as well? Wherever you find yourself, please partner with us. We are a resource for you, for the people that are in your life, your children, grandchildren, nieces, nephews, spouses, anyone who's going to be inheriting these assets. We want to be connected with those people as well, so that we can really help you keep that family wealth mindset to your estate and your legacy planning. So thank you again for your time on the webinar today. I hope you enjoyed it. Reach out to us if you have any questions, and enjoy the rest of your day.